Okay, we're going to cover the FAR bar, this FAR bar as is 5. We're going to cover section 16 under dispute resolution. So what happens if now there is a issue where either side can't come to an agreement of what will happen with either earnest money or what's going to happen with the results of the contract and so on and so forth. So paragraph 16, let's just read some of it and again expand on a few things here. Dispute resolution on line 339. Unresolved controversies, claims, and other matters in question between buyer and seller arising out of or relating to this contract or its breach, enforcement, or interpretation, any type of therein described as a dispute, will be settled as follows. Letter A, buyer and seller will have 10 days after the date conflicting demands for the deposit are made to attempt to relieve such dispute, failing which buyer and seller shall submit such dispute to mediation under paragraph 16B, which is the following. So if they can't come to terms of it, the first thing is going to go to mediation. Now, we have a brief discussion about the deposit. We cannot at any time, in spite of who we represent in the contract, advise them that they're going to get their money back, or they even should get their money back. The contract is clear on a couple of issues. First of all, if it's an as-is contract, as this is, and the buyer has their inspection during the inspection period and at their sole discretion elects to cancel the contract, we've already discussed in that section that is a get-out-of-jail-free card, that the buyer has the right to cancel the contract, no questions asked, as long as it's done during the inspection period, and the buyer can ask for their money back and should receive their money back. There are title companies who hold escrow that will release that money even if the seller doesn't agree to release it, when they should. All right, when it's clear, when the contract is clear and everything's been done according to the terms of the contract, then that person may release it, and there are a few out there who will release those things, all right, and get that done. However, if it's in a gray area, the other thing is if the buyer doesn't do what they're supposed to do in the financing clause, and we're in a situation where you are now past the loan approval period, and the buyer says, oh, I couldn't get a loan, so I want to cancel the contract and I want to get my money back, well, the answer is no, because you lost that right. We discussed that at length. So in that case, the money would go to the seller. And that same, attorney or title company has every right, in my opinion, to release the money to the seller in that case. So all things considered, there's some things there. But let's say we get into a gray area where it's not very clear, or that either the parties will not release the funds. Then it says that they have 10 days to try and work it out, and if they don't, then they're going to go to mediation. Now, what does mediation mean? Buyer and seller shall attempt to settle disputes in an amicable manner through mediation pursuant to Florida rules for certified and court-approved mediators and Chapter 44 Florida statutes as amended the mediation rules. You don't need to be an attorney and get into that. Someone can seek that. But if there's a dispute, they agree to go to mediation and try. And a mediator, remember, a mediator is non-binding, meaning it is not an arbitration where someone can make a determination at arbitration. Mediation means that they're going to try and get you in the same room and try and get this thing resolved. All right, and see if. And a lot of times it's splitting the baby, meaning let's just get half and half. Let's all move on because the cost of going to court is going to be very expensive, and so on and so forth. All right, so that's what that says, that you go to mediation. You don't need to know all that. You just need to refer them to their own counsel if they want to pursue mediation, and their counsel can help them find mediators that will take care of that. Continuing on, disputes not settled pursuant to paragraph 16 may be resolved by instituting action in the appropriate court, meaning let's go to court, having jurisdiction in the matter. So if you go to mediation, you can't get it resolved, then either party can go to court and try and get and seek relief or remedy in that manner. It says, note this paragraph 16 shall survive closing or termination of this contract, meaning that if we haven't agreed upon what's going to happen and no one has waived their right to seek other action like the seller did by accepting the deposit back up here in paragraph 15, then even after this contract is null and void, and or if there's closing occurred, then either party can still go after the other party and take them to court that has jurisdiction in this manner. So again, you get to that spot, you can reach out to myself or Jim or whoever's in charge of your office at that time, and then also you can and I'm going to probably highly encourage that your client, if they want to go after money or seek damages and so on and so forth, they need to seek legal counsel, and legal counsel can advise them on what the contract says and what their rights are under the contract. So that's paragraph 16, pretty straightforward again, but just you need to be aware of those things as they're there. All right, thanks. That was a pretty quick one, so hopefully we'll keep rolling through these.